So welcome everyone to part 2 of our training day. This second part we're going to be discussing something kind of very specific to the internal administration of the church. It's essentially a job that exists in every diocese around the world and exists in religious orders too, that often goes unnoticed, and for which, frankly, I have never seen a training course offered specifically for people who get appointed to this job. So I thought it would be good for us to have that kind of a training course, particularly because we have a new member of our team here at the Diocese of Sault Ste. Marie. A recent member joined our team, and that is Laura. Laura, who was hired initially as an archivist to help us with our church archives, but who now is also our acting chancellor. And part of the reason her title is acting chancellor is because we promised to give her training, specifically today's training and other things similar, in order to help her be able to grow into the full role. And so what is this role? It is something called the Ecclesiastical Notary. Ecclesiastical Notary. I just want to mention briefly to anyone who's going to see this online, either live or recorded, the idea of recording these sessions came in part through people suggesting it, but I also thought this particular session is important because, as I said, I have never seen a training manual or a video on how to be an ecclesiastical notary, and a lot of people get given this job as an add-on to another job they have in the church. So they're functioning as a secretary or some other administrator, and they get this added on. So it's nice to be able to have that training. So I'm hoping our video today will also be helpful in the future, even for other dioceses around the world. So if you look in our Code of Canon Law, you will not see the expression ecclesiastical notary. You'll just see the expression notary. But we often add the term ecclesiastical because in civil jurisdictions, they have notaries too. And often the title notary is a restricted title, just like not just anybody can go around claiming to be a doctor or claiming to be an engineer. It's a restricted title. Notary is a restricted title. And so if we just use the word notary, people might freak out, or it could create some awkward feelings. And so we add the term ecclesiastical to distinguish it. But the function in many ways is the same in church law as it is in national laws, other legal systems. A notary is a legal official. Just like in any legal system, you'll have certain kinds of officials like a judge, a lawyer, a prosecutor, terms like that. You'll hear similar terms in church law, and notary is one of those terms that you'll find is common. So what I'd like to do today, as I said, this is sort of a training video specific for one member of our team, but it's also good for all of us to know what it's about. I'd like to be a little more concrete and go specifically into what does a notary do. And if you're in another diocese and you're tuning in, and at some point your vicar general or your diocesan bishop comes up to you and says, I want to appoint you as a notary, your first question is, what the heck is that? Hopefully today will help you understand what you're being asked to do and what you're getting yourself into, essentially. So the word notary, if it sounds like the word notes, there's a reason for that. A notary literally is the note taker in its origin. You see, in the ancient world, particularly in Rome, people gave a lot of speeches, but they didn't write as many documents. It was a more oral culture. There's a lot of written documents, it's true, but paper was expensive. Not everybody had the skills of reading and writing and what have you. So a notary, if a politician, for example, was giving a speech, but they wanted to have that speech recorded, somebody would be there frantically taking notes in some kind of shorthand or what have you, and then would write it up for posterity, write up the contents of the speech. So the notary is the one who did the notes, acted as a scribe, you might say. Scribe, literally the one who scribes, the one who writes things down. Here's the thing, though. Not only did you have to have the skill for writing, That's a skill. You have to know how to do it. Not everybody could read and write. But you also had to be a person of confidence. Because if you were writing down what somebody else said, the question always becomes, how do we know what you wrote down is really what the other person said? And so the notary, as a function, is not just the technical aspect of writing stuff down, it's also a reputational aspect. You only get appointed to be a notary if you're considered a person who's trustworthy. So if you get asked to be a notary, take it as a compliment. Yes, it may involve work, but it means you are perceived as a person of trust. So in our canon law, for example, it says the chancellor and notaries, this is referring to church notaries, must be of unimpaired reputation and above all suspicion. Because if you have this function, you're in a sense in charge of the memory of the church, the memory as it is written down, not just, there is no brain memory for the church because the church is an organization. Our memory is preserved in a documentary form. And so if you're a notary, you have that. And so you're being asked to extend your trustworthiness to the work that you're doing. So that's the core job description, really. The ability to write and the ability, well, the trustworthiness that you bring to it as a notary. A lot of notaries in the church also have canon law training. Now, in civil law, especially in jurisdictions where notary is a public profession, like in Quebec, for example, not just anybody becomes a notary. You have to go for legal training for at least 3 years because you have the power or you have the task of drafting legal documents, not just copying them or writing the stuff down. You actually are an originating source. In church law, notaries often collaborate with that, but not necessarily. And so we do have a stronger distinction between a canon lawyer and an ecclesiastical notary. But you'll find that often the two tasks will overlap, and so people who are asked to do ecclesiastical notary stuff start out with simple jobs. But then over time, as they acquire experience, they may get sent for canon law training and what have you to be able to undertake some of the more technical exercises. So that's the core of what it is and where it goes. Now, I mentioned that we have a new chancellor, an acting chancellor, later to receive the full title, and this training is in part to help her with her role. And she started out as the archivist. Well, archivist is also in charge of the memory of the church, right? Archives are the memory bank, literally. And so a chancellor in the church is also a notary, automatically, de facto. The chancellor's job, principally, is to look after the archives. That's the memory bank. So the chancellor also becomes a notary for reasons we'll see in a moment, because you also have a responsibility for the memory of the church. And a chancellor in many dioceses has canon law training. It's not actually core to the job description, but it's often the case for the same reason why notaries will get canon law training, to be able to be the originating source for stuff, not just a copyist. So those are the layers that we'll see for a chancellor. So for our acting and future chancellor, you have your career path set out for you right there. So, again, my presentation today, I'm trying to keep it, we're not going to do the full canon law stuff as if we were trying to get a degree in canon law. It's just for the ordinary person working in a diocese, such as ours, who gets asked to be named as a notary. Currently, in our diocese, we have 2 people named as ecclesiastical notaries, and a third who has it by default. So, Robert, you are an ecclesiastical notary. That was one of my first appointments, was to give you the official title. Danielle, you were also a notary in another context, and you now are for our diocese. And of course, Laura, as acting chancellor, you have it by default, de facto as part of your job description. But in theory, anybody here could also be named to the task. As an aside, I learned when I did my sort of baby bishops course in Rome, it's a kind of a course they give people who've recently been appointed bishops, that a diocesan bishop is also automatically considered a notary. Because honestly, if we have the authority to appoint the notary, then we should have the authority to do it ourselves. It kind of makes sense. So what is the core function of a notary? There's the order in which ordinary people get asked to do the job, but then there's the order in which the job evolved historically. So I'm going to put both on the board and you'll see the order of things. Generally, if a person gets asked to be a notary, remember it starts from taking notes, right? That's the historical origin. But usually when you get asked to be an ecclesiastical notary, the thing you find yourself doing most of the time is countersigning documents. So, counter signature. What does that mean? Well, suppose you have a document, the bishop writes a letter or a decree, and it carries authority. It's not just, happy birthday cards. It's making some sort of disposition within the church, some structure of the church. So there's all the content of the letter, and then the bishop signs. So his signature. But here's the thing. How do you know the letter's not a fraud? Normally, on checks, for example, you want at least 2 signatures, right? Now, 2 people can collude, but if you've got 2, it certainly cuts down the risk. So for church documents, to avoid any appearance or question as to what this is, why is this way, you have a counter signature. The counter signature is done by the chancellor, the vice chancellor, or an ecclesiastical notary. And so very often, for those of you who have done the function, you find we go through a document, it's written, and then it's just given to you to sign. And your job in countersigning is not to validate the contents. It's not like with a check where the second signature, you get a chance to say, whoa, what's this about? All you're doing is authenticating the fact that the original signature really did come from the bishop or the vicar general or the episcopal vicar, the person in authority. That's the core function. And so if you are confident that it really is them, then you can add your counter signature. That's the core idea of countersigning. Very simple task. Very simple. But again, because you are affirming this really is true, that's why it requires someone of unimpaired reputation, that, like we heard in that canonical explanation before. So that's countersigning a document. Another function, very, very similar, is witnessing a signature. Here you're witnessing a signature by doing that, but you could also, for example, a form of witnessing a signature would be for an affidavit. So somebody comes in to sign an affidavit. I officially certify that the following is true, and I, under pain of perjury, whatever, you sign to show that you have witnessed that person. And so you can also be witnessing them make an oath. You could be witnessing them making some kind of public promise. So now we're getting into the realm of it's not just witnessing a single signature on a paper. You may be witnessing the whole testimony of a person. So now you see that the job starts to become a little more developed. You're witnessing a signature. They may come in with a document and they just sign it, but they have to sign it in front of someone else, so that's the affidavit. However, what if you are asked to write up the affidavit? Somebody comes in, makes a declaration, but they haven't written anything down. So the notary may be tasked to write the minutes of that declaration, to actually write up the declaration and sign it. So there's an element in court. In court, before we had all kinds of video and audio recordings, how did they keep court records? Or in Parliament, they would have armies of people, stenographers, right, who would write down every word the judge said, every word the witnesses said, every word that was said by the lawyers. So there's a stenographic function. Being a stenographer is sometimes part of the job of a notary. Now, modern day, because we do have lots of recording devices, it often is not direct stenography from live voice, it's transcription. So your job is to take an audio recording and type it up, if you're an ecclesiastical notary. But again, going back to the thing, how do you know what is written in a document really is what was said on tape or what was said in the audio? How do you know? You need the person who's doing the transcription to be an honest person. And so their signature at the end is basically a way of saying, I certify that this is a true duplicate of the actual interview or the actual declaration that was made. And that's why it's not, we can't do stenographic transcription simply by feeding the audio through a piece of computer software. You could do that to make it faster, but a human being actually needs to listen to it, compare the text to the audio to make sure what's there is legit. And they put their signature on it. Tied to this, what's another common job for a notary, an ecclesiastical notary? Thing that people just love to do so much, minutes of meeting. Yeah. You know, it's a real art. Writing good minutes of a meeting is not easy. I have seen minutes done, you know, you're in a meeting and they sort of, oh, who's taking the minutes? Everybody kind of looks down or looks at the floor, you know, and they say, oh, come on, somebody should have, fine, I'll do it. And they do it, and you know, sometimes you get minutes that are almost like a transcription of the whole meeting. It's a 20-page document. Sometimes it's just very, very brief summaries. There are different schools of thought as to how to do minutes, the level of detail, not enough detail. I remember I was involved in a legal dispute, not me personally, but I had to assist in it. And the minutes of the corporation were brought as evidence, and there was this protest that said by one of the parties, these minutes are not detailed enough, they're worthless. And in fact, the judge agreed. The minutes only contained the final decision. It did not contain any of the rationale for the decision. And so therefore, because the judge couldn't determine the reason for the decision, the judge was going to interpret it according to his own point of view. And other people were like, but how can you do that? There's nothing there. But that's the problem. How much detail do you put in? How much do you leave out? It's a bit of an art form, and I mean, I can't do a training session on... We could do a training session just on how to write minutes of meeting, but that'll be for the future. We're not going to do that today. Just to say that if you're an ecclesiastical notary, if you're a chancellor or vice chancellor, you can expect you'll be asked to do this. Now, sometimes people don't have that skill. These are a series of skills. Again, it's an art form. If you're the chancellor of a diocese, maybe you got that job because you have a degree in canon law, but not because you were trained in doing minutes of meeting. That's why you have staff to help you out. But it's whoever puts their signature on it and says, this is true. Another function tied to this is producing official copies. Official copies or extracts. Now, what is this about? If you go to older dioceses, you go in the archive of an older diocese, you will find what they call a minute book. Now, the minute book often today is seen simply as a collection of individual documents called minutes of meeting. But in the older concept, the minute book wasn't just minutes of meetings. It was every single decree that the bishop issued. So the decrees would be written into this book, and then they'd be signed, countersigned, and then copies would be made from that original book. The copies would not be signed by the bishop again. They would simply be signed by the notary, certifying that it is a true copy of the original signed in the minute book. So the bishop only had to sign once, countersigned by the notary, yes. The bishop signed once, but the notaries could produce as many official extracts as were needed. We see this today with companies. The corporate secretary's job is often to preserve the minutes and produce extracts from the minutes when it's necessary for a particular copy of a resolution to go to say, well, this is what the official decision was. So that was often the way that worked, producing official copies or extracts, which means that, nowadays if you have an original document, your birth certificate, and you need to make a copy of it, you can go to a lawyer or a notary public. They will run it through the photocopier, but they will then put a stamp and their signature on it saying, this is an official copy. Well, what's wrong with the photocopy? Well, things can be counterfeited. The idea is you need a human being who's known for their integrity, and a notary public is appointed, right? They have an appointment from the government for this. They're accountable. And so their signature acts as a kind of public witness as to authenticity. Well, it's the same thing for an ecclesiastical notary. Nobody can go around saying, I'm an ecclesiastical notary because I'm an honest person. You have to be appointed to the task. And then you have this ability to produce these kinds of extracts for any official purpose. Now, tied to this, now if you notice, this is all documentary stuff, and it's essentially paperwork. And so people who get appointed as ecclesiastical notaries very often are administrative personnel within a diocese. But if you notice, a lot of this kind of stuff is echoed in parishes. If we have any parish secretaries who are watching this video, you're not ecclesiastical notaries per se. You could be appointed one. And a lot of this stuff, for example, the minute book, right? Creating official copies. Somebody phones the parish and says, I need a copy of my baptismal certificate. What do? You go to this register. That's the minute book, where the official decree original is kept of this person was baptized on this day. And then you produce an extract, the baptismal certificate. And then somebody in authority needs to sign it. The pastor, usually, the one who is the keeper of the register, although if a parish had an ecclesiastical notary, that person in theory could be given the authority to produce those under their own signature without it having to go to the pastor. It's theoretically possible. Minutes of meeting is that, like I mentioned, the word secretary for a corporation. Often in a parish, you'll have committee secretaries or the parish secretary who will sit in. Not every parish secretary, this is a particular skill, not everyone has it, so it's not necessarily their job, but it is handy. Oh my gosh, if you've got somebody who's good at this. I knew one person, in a former life who, my former life, before I moved to Ontario, who was so good at this that she made a living just being hired out to small and medium-sized companies to prepare their minutes for their company records every time they had to file something, etc. Just maintained corporate records. That's all she did. She wasn't a lawyer, but she knew what she was doing, and she wrote excellent minutes, and so it was a prized task. These other things are fairly straightforward. Stenography, transcription can be very time-consuming. This kind of notary is often found in an ecclesiastical tribunal. So if you're doing marriage annulments, for example, declarations of nullity, and witnesses are coming forward to give testimony, you'll record it, but somebody needs to write down the testimony and sign it to say this is a copy of the true testimony that they gave. And very few people come to a tribunal with their testimony all written out in advance. Most of the time they just speak live, and it's better that way because it's fresher, it's more authentic. But you need a copy. And so ecclesiastical notaries who work in tribunals usually get a lot of that kind of work. So these are the basics, which we see duplicated in different church scenarios. But there's something about being in contact with documents. Over time, you begin to notice similarities. You begin to acquire experience with these things. Take a bishop's decree. So you read the decree, the bishop gives it to you, or the vicar general gives it to you and says, okay, I've signed this, please countersign it. And you're about to put your pen on it, because all you have to do is certify that the bishop signed it. I mean, that's all you're being asked to do. But as you look it over, you say, Bishop, it's the wrong date. Instead of putting 2021, you put 2012. And I don't think it's 2012. I can't authorize something that claims to be from 9 years ago. So maybe we should fix that. Or, and these things happen, you know. Or maybe somebody added a digit. It's the year 20,021 or something. You know, an extra zero got put in. Or maybe you're reading the contents of it and you see, oh, there are typos. Oh, there are, the name is wrong. The name of the parish is wrong because they copied from another document to make the new one and they didn't change something in it, you know? These things happen. As we get used to looking for typos, so often the notary acts as a proofreader. So that may be, these are sort of unofficial things. They're not necessary to the fact that you're putting your signature on it, but because you're putting your signature on it, it's a good idea to do. So, proofreader. And by the way, there's nothing wrong with that. If you're a notary and somebody gives you a document that says, sign this, don't ask any questions, you should start to ask some questions. At least for yourself, do I want to be doing this? Because don't forget, you're being asked to put your reputation on the line every time you sign one of those documents. So, theoretically, the reputational risk is small. It's just certifying the other person signed it, but do you really want to have your name on something that's full of spelling mistakes and the wrong date and you know, as they say in French, de la schnout, you know? Is that really what you want? I don't think so. So as we acquire experience as proofreaders, as we acquire just through exposure to these documents, sooner or later, the bishop or the vicar general or whoever is going to say, yeah, you know those 50 decrees you've already signed naming a priest to a parish, you know, for various priests to various parishes? I need decree 51. I don't have time to write it myself. Just take a previous copy and make a new one, change the name. So you wind up becoming a drafter of ecclesiastical documents. Usually from a template, you know, from a former copy where we adjust the words. But often the proofreader becomes the drafter. So you get told, these are the parameters of the document I want. Please come up with a text. Now you can see why notaries eventually go for some kind of canon law training. Because it's great if it's just fill in the blanks or start from the last decree. But after a while, we start to have to do tweaks. You know, that's not a parish, that's a mission. Or the parish is the cathedral. Do we name a pastor? Do we name a rector? Well, all these little questions start to pop up. What's the right way to do this? Is there a nuance we need to bring? A decree usually has a section at the beginning called the whereas clauses, which gives the background as to the decision. It's not just the decision, it's the why. That will be different from case to case. And so sometimes it's a blank template you can apply. Believe it or not, there are publications out there of just books of sample letters, sample decrees that you can buy and just copy and adjust the wording just to help dioceses and religious orders get their ducks in order and have proper documentation. So those exist. But even then, there's always going to be something that comes along that's a bit different. So, drafter from templates of some kind to original drafts. Now, even chancellors with canon law doctorates very rarely invent this stuff off the top of their head, you know. Suppose it's something really unusual, the kind of document you don't see very often. The bishop wants to have somebody canonized. Wants to open a process for, you know, Madame Tartampion to become Saint Tartampion, wants someone, Mr. Who's-he-what to become Saint Who's-he-what in the diocese. How often do these decrees get issued? It's not every day. So what do? Well, they phone up the other dioceses where this happened. They say, you did that 5 years ago. Could we get a copy of that? Because we're thinking of doing the same thing. So there's a certain osmosis that happens. But regardless, a bit more thought needs to be put into it. So this is why notaries, just through exposure and paying attention, often pick up a lot of canon law experience and eventually get sent for some canon law training. Not to become canon lawyers, but just to get a better sense of what it is that they're touching, they're working with, and the better they are at it, the more they're going to be asked to make original contributions, the more they're going to be asked to contribute. Sometimes an ecclesiastical notary will spend their whole time as a notary simply countersigning the occasional document. Sometimes it'll be more developed, their contribution. Sometimes it's actually helping to craft the documents of governance to things that can be even very complex, like the rules of a religious order, the rule of life of a seminary. I mean, these are highly detailed, complex things. Usually you need a lot more experience with that, so that's where you start to get into true canon law. But you never know, it could go there. I know that in my former diocese in Montreal, in the Chancery office, we had a chancellor and a vice chancellor, both of whom, at the time when I was there, both of whom had degrees in canon law, but there was a staff, many of whom were notaries, some of whom simply countersigned documents, but over time they were given continuing education to learn more about canon law so as to be able to contribute in these ways. It's good for everybody, right, to get some training. Now, in a diocese, because the chancellor is the archivist but also a notary, very often a chancellor is hired for their canon law experience, not for their archival experience or for their, notarial, sort of more secretarial type experience. But that's why you need additional notaries. In our Code of Canon Law, it says, by reason of being chancellor and vice chancellor, they are notaries and secretaries of the curia. And then it says, besides the chancellor, other notaries can be appointed whose writing or signature establishes authenticity. All the stuff that I just described here. Now, there is an additional little detail to add for those of us who are notaries or maybe appointed notaries. And that is appointment as a notary. First of all, it comes from an authority, right? And so you are not a notary at large. You're a notary for the jurisdiction that appointed you. So a person who is appointed as a notary in the Diocese of Sault Ste. Marie is not automatically a notary in the Diocese of Ottawa. Okay? But very often, what happens is a person gets multiple appointments for the multiple areas of jurisdiction, because if you've got the skills, why not? It makes sense. So the scope of your notarial role depends, first of all, on the jurisdiction that has appointed you. And then secondly, within that jurisdiction, as it says in the code, you can your signature establishes authenticity for any acts, for judicial acts only, or for acts of a certain case or affair only. So in other words, there are people who are appointed for all acts. Then there can be people who are appointed notary, but only for a tribunal. So let's say if it's a marriage tribunal, they're appointed only for the tribunal, even within the broader diocese. Within Montreal, we had some ecclesiastical notaries who had general signature authority and others who was specific to the tribunal. Because the tribunal I mean, it's a machine, right? A marriage tribunal, a busy one, it just is constantly receiving testimonies, it's constantly doing transcriptions, it's constantly issuing new decrees, and the notaries, in some cases, almost run the tribunal in terms of its ongoing day-to-day paperwork. And so you can have notaries for all acts, you can have notaries for judicial acts. And then it says in the code, for acts for a certain case or affair only, sometimes there's a specific issue that's being looked at, and so you appoint a notary specific to that case. I gave the example of the bishop wants to have somebody canonized. Well, when we want to have somebody canonized, we actually put them on trial. The dead person goes on trial, not to prove they're guilty, but to prove they're holy. If you've ever heard the expression, the devil's advocate, it actually comes from canonization trials, because just like in a regular trial, you have a prosecutor who's trying to prove something and the defense who's trying to prove the opposite. Well, if you're trying to prove someone is a saint, you need somebody to prove they're not. So that person was the advocate, the lawyer for the devil. So they were the one whose job it was to kind of pick holes in the cause of sainthood. That's where the expression comes from. So if you're literally putting somebody on trial, quote unquote, to prove they're a saint, well, you need a notary because it's a judicial process. And so you need a notary for special cases. There are some limiting cases where the notary must be a priest, although the Vatican has dispensed from that from time to time. Usually, if it's a clergy case, then the notary is a cleric. But again, that has been dispensed in more recent years in specific cases. So all acts, judicial acts, special cases. So you don't get named notary in general, you get named notary for that specific case. And it's usually time-limited appointment. Once the case is done, then you're done. Your role is finished. And so if you are ever asked to be a notary, and this is for the people out in internet land too, if you're ever asked to be a notary, this is the kind of thing you may be asked to do. This is the kind of training that you may be asked to follow, or you could even ask yourself, say, I would like to learn more about this, that, or the other thing. And you will want to know, based on your letter of appointment, what the scope of your authority is. For example, in our diocese, Danielle, you were a notary before I appointed you a notary.
Yes.
But you were a notary for the Tribunal
Yes.
of Toronto,
Right.
which is a regional tribunal. So why did I appoint you a notary if you were already a notary? Well, the answer is because you were a notary for judicial acts of a specific tribunal. Now you have a second appointment so you can countersign all acts in our diocese. So I couldn't appoint you to Toronto. Strictly speaking, it has to come under the terms of the Toronto Tribunal. I believe the individual bishops are involved in that process, obviously. But by giving you that second appointment, it expands what you can sign for. And so, for example, Laura, as acting chancellor, in the decree, when I appointed you as acting chancellor, I made sure to add a paragraph that said, for clarity, she has the power of an ecclesiastical notary. Because the code doesn't say anything about acting chancellors. So I didn't want anybody in the future to say, well, she was acting chancellor. Does that mean she could sign these things? Just make it clear. That's why I put it in there. And there's an example of needing a bit of creativity in the drafting. Acting chancellor, it's not really in there. What do we do? How do we cover all the bases? It requires a certain amount of experience. Dowd, you are the first person I appointed as a notary in our diocese. At the time, Father Jean was the chancellor, and so he was automatically the one countersigning. But if he was going to be out of the office, if he was not available to countersign, I wanted to make sure there was a backup. And you are an expert in canon law, and so you have contributed much to the drafting side. It's not just countersigning, you've contributed much to the drafting side. So I'm very proud. We have a team of people with different backgrounds and different expertise, and who are learning and growing. And I mean, the church is not supposed to be just a document factory, right? We're a holiness factory. We're a saints factory. We're a grace factory. That's what we're supposed to be about. And so this may seem like a lot of detail. And it's true, the kingdom of God is not built through having efficient administration. The kingdom of God is built through, people are laughing, but it's true. The kingdom of God is built through charity. It's built through doing good, loving your neighbor, worshiping God. That's how the kingdom of God is built. But I can tell you, bad administration really gets in the way of building the kingdom of God. And frankly, mediocrity, not bad, just mediocre, means often we have to do rework, we have to do it again. And because part of this job is about the institutional memory, when it's done well, coupled with a good archival function, it means when we have to remember what did we do last year or 10 years ago, it's a lot easier to refresh because people come and go. People who have worked in an institution like a diocese for 10 years, they eventually retire. And when they go, they take all of that knowledge with them. This is a way to preserve it so that we can build on it for the future. And I'm sure anybody who's watching who's a parish secretary knows, very often you are the institutional memory for your parish. Priests come and go, others come and go. You're the one who knows everybody, and I like to say, where all the bodies are buried, sometimes literally, because you have the funeral register, you know where the cemetery lot is. You literally know where the bodies are buried. So that kind of institutional memory is very, very precious, and we need people who we can trust and who understand their role is one of service. And so I hope this is useful background for what a notary is. I think a lot of it is fairly self-evident. Once you present it, you kind of go, oh yeah, okay, that's it, sure, I knew that. But the term notary it's jargon, right? Until we know what it contains, well, maybe it means something else. So at least now we're on the same wavelength. Are there any questions regarding this brief presentation? Yes?
Can a pastor of a parish name their secretary ecclesiastical notary, or does it have to go to the bishop?
Can the pastor of a parish name someone as ecclesiastical notary? It doesn't have to go to the bishop. Robert, you asked the question. You already know the answer, but thank you for asking it because you're giving me a chance. The pastor does not have the authority to do that. The ecclesiastical notary is appointed by the bishop. A pastor could certainly request it. The appointment to someone to an ecclesiastical office has to be given by the authority for that office. In the case of a diocese or within any of the diocesan structures, that would be the diocesan bishop. Robert just gave me the thumbs up, so.
So the fact that I'm notary, ecclesiastical notary here,
yes,
am I automatically notary at the parish where I work?
It would depend on, does your set of appointments allow for that? Before, as notary for the tribunal, the answer would be no. Now, as notary within the diocese, without any restrictions on the act, I would say yes, you can certify things. Absolutely. I would talk with your pastor before you go off signing a whole bunch of stuff, but obviously, yes, there's something to that. By the way, within the civil administration here in our province in Ontario, we have roles similar to this. There is a role called a Commissioner of Oaths, and the Commissioner of Oaths for Ontario legal documents can witness signatures, can receive affidavits. I was a Commissioner of Oaths in Quebec, and I had an appointment that was valid for all of Canada. That meant that I could go anywhere in Canada and receive an affidavit. It was only useful in a Quebec courtroom, but I could get it from anywhere in Canada. And why did I seek to become a Commissioner of Oaths? Because as an auxiliary bishop, I would sometimes encounter people who had important testimony to bring for the life of the church, a complaint or something like that. And by being a commissioner of oaths, I could receive their testimony directly instead of telling them, come back in 2 days. So that was very, very important for me. Here in Ontario as well, a step up from a commissioner of oaths, we have a notary public. All lawyers and paralegals, I don't know if it's true for paralegals, all lawyers in Ontario are automatically notaries public as well. Paralegals and other people who apply and who can demonstrate why they need to be a notary public, they have a valid reason, not just because they want another thing on their CV. They have a reason, and the government will do a background check similar to us. It has to be someone who's honest, somebody who's grounded, somebody who has roots in the community, somebody whose reputation is unimpaired, which usually means a criminal background check and that sort of thing. You can apply to be a notary public in Ontario. And so I know in Quebec, in our chancery, I was a commissioner of oaths. I had my executive assistant appointed as a commissioner of oaths. Somebody in our chancery was a commissioner of oaths. And that person, when they retired, we actually had to keep coming to my office to get things signed by the commissioner of oaths. In Quebec, we also have notary public that exists, a notaire civil. However, that is a much more extensive process. Here in Ontario, it's simpler. In Quebec, it's a full-blown profession with its own equivalent of the Bar Association. And they not only, authenticate documents, they help people prepare wills. But there's an example, the notary who helps draft documents. So in Quebec, the notary has an advanced training to be able to prepare advanced documents like land deeds, wills, and that sort of thing. And they have a minute book that they record everything in. So it goes back to the ancient profession. Any other questions? Well then, thank you very much. Oh, wait.
There's one question here in the chat. It's about the previous presentation this morning. If you're in a small parish and all we have is a parish council which takes care of the finances and other affairs that concern the church, is that okay?
Okay. Any questions for the previous presentation, we'll have to answer separately. I want to keep our presentations distinct. But thank you for that. We'll get back to that. Maybe we can answer it in the comments on the other video. Okay. Merci beaucoup. Thank you very much. Thank you, those So Laura, get ready to get training. All our notaries, get ready.
All right.